Women's IP World. Women's IP World. Women's IP World.
Welcome to episode 6 of season 4 of the Women's IP World Annual Podcast, a podcast series that's shining a spotlight on women in intellectual property. I'm your host, Michele Katz, and I'm the co-founding partner of the law firm Advitam IP, which in Latin means intellectual property for life. We are based out of the US in Chicago. Me and my firm are hosting this podcast on behalf of Northens Media PR and Marketing Limited, based out of the UK and London. They are the publishers of the Women's IP World Annual and the Global IP Matrix magazine. The 2024 edition of the Women's IP World can be found digitally at www.womensipworld.com. Again, that's www.womensipworld.com. And you can listen to the annual as well on your favorite podcast app. Keep an eye out, of course, for hard copies, if that's more your thing, at all the major IP conferences going on worldwide. I'd like to welcome Sarah Norkor Anku, founder of her firm, SN Anku IP Firm in Ghana. Thanks for joining, Sarah.
Thank you very much, Michele.
From sunny Ghana.
Yeah.
It's great because I can see you in the sun piercing through your curtains. And of course, behind me is rain in Chicago. But I'm glad you could be here with us.
Thank you.
I know that you're in Ghana, but your practice goes beyond Ghana, correct?
Absolutely.
So my understanding is, the African region, or at least part of it, is called a repo. Is that right?
It is.
Can you give us a little bit more details about a repo and what that region covers?
So in Africa, we have 2 regional bodies that administer intellectual property. And that's OAPI and ARIPO. ARIPO is the African Regional Intellectual Property Organization. It has 22 member states, and the member states include Ghana and Gambia, Liberia, and most of the southeastern African countries. We are mainly English-speaking countries, and we run a unitary system. That is to say that when you put in an application at a repo will seek the approval of the member state before it is granted, to have effect in the various member states. So for instance, if I have a trademark or I have a patent that I want registered within the repo regions to cover the member states, then the member states will agree as to whether they want the mark or the patent registered in their country. So that's the system that is different from what we have in the OAPI system. The OAPI system, you have one application that covers the whole of the region. So for us in Ghana, for SN Anku IP Firm, we have offices in the Gambia and Nigeria. And Gambia is a member of the Banjul protocol that covers the administration of trademarks within the ARIPO region. Ghana is not a member of the Banjul protocol, but having an office in the Gambia enables us to also register trademarks within the ARIPO region. But when it comes to patents and industrial designs, we are able to register for our clients through the ARIPO region. And Nigeria stands on its own. Nigeria is not a party to ARIPO. So we have a separate office in Nigeria, and we use that to service our clients within Nigeria. So ARIPO basically handles it's a regional body that handles the registration of IPRs, especially the industrial properties. But recently they've added copyright as well as the plant variety protection for clients as well.
So patents and trademarks too?
Yes, patents and trademarks.
Okay, so it probably started with those. Those were like the primary,
Yeah,
I would imagine,
yes,
right? Okay,
yes.
it's expanded. And are all of these countries that are part of Arepa, you mentioned that they're English speaking countries, so that's the primary language people are filing in?
Exactly. That is it. That's the language for Aripo. But we have other countries like we have Mozambique, we have Cape Verde that are not
Hmm.
English speaking, but they're all parts of the Aripo states.
Okay. And the filings then can be done in English.
Exactly.
And is there, so I, in Ghana is common law. I recall reading from your article
Exactly.
that common law is, the legal framework and the system there. Is that the same for many of the other, repo countries?
For yes, many of the English speaking Aripo countries,
Okay.
yes.
Okay, well, let's go back a little bit. That's kind of the macro view. I want to get a little bit more micro with you. And based on your bio, it seems that your practice covers all aspects of intellectual property. Did I get that right?
Exactly.
Okay. I could feel your passion for intellectual property and reading about your involvement in making, IP policy in your country and beyond. With your position as the Arepo source for the judges colloquium in Namibia.
Maybe,
Yeah, I was
yeah.
like, okay,
Yeah.
which is incredible. Taking on landmark cases that have shaped IP law in your country, all your authorship, your teaching. There's a lot there, and it's actually a really fascinating bio read. A lot of times, that's not the when you go to an event and there's a long bio and there's this article, it's like a really compelling bio that you've included in the magazine. I was wondering if or when you might sleep. That actually came to mind as I was going through your bio. It's really incredible.
Yes.
Um, I won't let you reveal your sleeping secrets, but it did come to mind.
Yeah.
So I want to go back to the beginning. How did you fall so deep in love with intellectual property?
It just happened by chance, I would say, because I didn't know anything about IP until my latter part working with the Food and Drugs Authority in Ghana when we had issues on counterfeits that we had to address. Subsequent, so I had to help the lawyers. I was put on a particular schedule and I was going to court with the lawyers. So subsequently, I decided to read law and I took the course at the law school, but that was not enough. I came back and I joined the IP office as a state attorney. And it was there that I developed intense passion for the subject. And fortunately for me, I also have a science background. So that also facilitated my passion for patents
Hmm.
because I tend to understand the subject better and I tend to understand the documents that I read on patents. So that I believe also contributed a lot. And I did a lot of work within the 9 year stay in the Registrar General's Department as a state attorney in the IP office. And subsequently, I decided to try what happens on the other side, that is going to
Private
private practice
side.
and know exactly what. Yes. So that was when I stepped out and I also added lecturing. So I lecture patents actually. I lecture patents and industrial designs on an MPhil program in one of the universities in Ghana. And I've had the opportunities to talk about it over and over many fora. So basically, I think I just chanced on this. I just chanced on it, and I love it.
It was destiny, I think.
Yes,
So you mentioned your science background. Was that university studies?
exactly. I have a first degree in biological sciences.
Oh, okay. I did not
Yeah.
know that. Okay, wonderful. And so at one point, did you start your own firm?
So, well, it was in 2011. I was still with the Registrar General when I established the parent firm, that is Anku at Law. But I realized the conflict situation, so I handed it over to a partner. and the partner took up the firm whilst I continued my work with the Registrar General. So in 2018, I decided to take a break. I took a 6 months break from the Registrar General. And during that time, I tried my hands on what really happens on the other side, the private practice. And after that, I decided to resign from the Registrar General's department fully. So I resigned in December 2018 to focus on my private practice. So I went into Anku at law, and I was practicing from there. So the last time we met, I was actually with Anku and Anku at law. Then in 20 latter part of 2022, we thought that we should really carve out a whole single purpose vehicle for IP. There's nothing like that in Ghana, but so we thought we could just try that and see. So we carved out the IP department from the Anku at law and established the SN Anku IP firm, so the IP intellectual property firm.
Ah, okay.
So just to focus on end-to-end IP. That's also I have staff who do that, just focus on IP.
So in Ghana, the idea of the boutique firm didn't really exist, or not
No,
in IP.
no, no,
Okay, so
no.
you basically pioneered that. Have you noticed? Have other people kind of followed?
I haven't noticed any other yet. Probably because it's a growing field. It's now coming up. So probably with time, I will get others joining me in this. But for now, the law firms that practice IP also have other areas of practice.
Well, which is in line with what's customary in your country.
Exactly.
Unlike here, I mean, now, of course, in the States, you've got these giant firms with different departments, but there are still the niche firms that exist, um,
Exactly.
like mine, for example, for Advitam IP. Okay, so hold on to that thought. We're going to dive deeper into Ghana and IP law in Ghana after we take a quick break.
The results are in. Discover the top 100 influential women leaders in IP law, champions of leadership, innovation, and global influence 2025, now at www.womensipworld.com. Would you like to be recognized in next year's rankings? Be part of the top 100 influential women leaders in IP law 2026 by subscribing today and staying informed on when submissions open. Visit www.womensipworld.com and subscribe to stay in the loop. The Women's IP World Rankings 2026, celebrating excellence, leadership, and impact in the world of intellectual property.
Welcome back. We are on page 88 of the 2024 edition of the Women's IP World Annual. For those who want to take a look of the digital or hard copy, feel free. The article that Sarah authored is Managing Business Intellectual Property Rights in Ghana, a Practical Perspective. Practical is good. Practical helps our clients understand better and helps us understand when we're describing to our clients where they should look towards, right, for IP investment. So naturally, businesses who are looking to Africa for expansion and profitability will want to pay close attention to Sarah's article. Now, why Africa and why specifically Ghana? What would you tell clients who are abroad?
I would say that in Africa, we have this new trade area which covers a market of more than 1.3 billion. We have a middle class group that have a taste for luxury products. They have a taste for foreign goods, imported goods. They are particularly interested in brands. So, with that, it creates an opportunity for third parties to take advantage of existing brands. So if you want to secure your brand in Africa, you have to pay particular attention to what goes on in our IP system here in Africa. And that also applies to Ghana. We are developing, we are a safe haven for people, for investors. We've had an election, it's been safe. So Africa is a place of interest for investors now, particularly because of the new African continental free trade area that covers over 1.3 billion people, with quite a sizable number being in the middle class with interest in brands, selling luxury goods that investors may be interested in doing business in. For Ghana, our population is over 30 million people. Of course, we love luxury goods, we love imported products, and we have a very stable political environment. We have the needed infrastructure. It may not be the utmost best, but at least we are getting by. We are doing quite well. Our economy is a bit slow, but it's picking up over time. We recently had an uneventful election, and which we are proud of. And so basically, you are safe to come to Ghana to do business. And I believe that being a new area of destination for certain products, I think that those in who are interested in the African markets must pay attention to our IP systems in order to make sure their IPRs are secured in Africa. You will know that we have a fragmented kind of legal systems. We don't have a unitary system across Africa. So when coming to Africa, you have to be guided. And you investors must be mindful of the fact that what pertains in other jurisdictions may not pertain in Ghana or Africa at large. In other jurisdictions that are more advanced or more developed, you will find a smooth sailing IP system so that you are sure that, for instance, if you want to register your trademark or you want to apply for a patent, you know that it's going to take a particular time to get granted, and you know what kind of office actions that may be required of you to do in the course of the prosecution process. But it doesn't necessarily follow same in our part of the world, in Africa at large, and in Ghana in particular. Mainly probably because we do not have enough resources for the IP officers. So for Ghana, for instance, in Ghana, there's a lot of backlog. So a trademark registration that should ideally take about 6 months could take a year or two or even more if there are issues with the application process. So it is good to come to Ghana. It's good to come to Africa to do business here because, of course, this is the market. We have the market here, and it looks as if we are beginning to build our economy in such a way that we can afford certain products and services as well. But in so doing, as an investor and as a lawyer, an IP lawyer, I would encourage you to pay attention to our IP system.
From other jurisdictions? So you're saying you can take other jurisdictions because that's where that would be a big difference than here. I was trying a case before the federal circuit, and the other side was desperately trying to get in the 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 trademarks just because they were registered in another country, and the federal circuit here struck, I mean, just was, it's like not relevant. It's like just relevant, which of course was in our favor for that particular case. But I could see how, desperate the other attorney was trying to get it in to prove what he was trying to prove. So that's something that is allowed actually in Ghana. It is interesting. It's persuasive.
For
Yeah.
Ghana, we are still filing in person, but Aripo
Hmm.
provides for online filing. But what it is that it still remains that if a foreigner, someone outside, an investor, a business person, somebody, an IP, a rights holder coming from outside our jurisdiction would need to use the services of a registered IP practitioner in order to access these IP systems in Africa.
Hmm. Hmm. Yeah, it
Yes.
has a binding effect. Interesting. That's super interesting. So, when you're thinking of, I, IP owners, filing in Ghana, what are some of the biggest challenges they face?
For the common law, I think it cuts across. It cuts across. It means that we also rely on precedents. So court cases from the high courts are binding on the lower courts. So you have the Supreme Court case binding on all of us. There's Court of Appeal binding on the High Court and the other courts below the High Court binding on the lower courts. And for other cases, decided cases from other common law jurisdictions, those cases become of persuasive value to the courts. It means that they are not binding on the courts, but they have persuasive value. So, what I've realized in practice, because jurisprudence is at IP jurisprudence is at its early stages, we do not really have enough precedents to go by. So, what I have done personally is that when I have my IP cases before the court, I rely heavily on decided cases, say from the UK, even from the US, and other common law jurisdictions. And many a times they have served my purpose because the judges end up ruling using my cases that I have cited. And so when that happens, those cases also become precedents for Ghana.
My word, I didn't realize Ghana didn't review. I mean, I've gotten office actions from other jurisdictions, so that I know that they do get reviewed in some
Mm.
countries, but Ghana doesn't review. They just rubber stamp if you file the really if you file through Madrid.
It is persuasive. Yes, it's persuasive, meaning that the judge is not bound by it, but the moment the judge accepts it and it finds space in the judge's decision, then it binds us all. The first challenge is the application itself, registration at the Ghana Industrial Property Office. I mentioned earlier on that they have challenges with logistics, resources, and even human resource itself. They have so many cases that they have not handled, and so there are so much delays. So that's the first thing. But the advantage here is that the application once put in, as just as it applies in other jurisdictions, the application once put in, the filing date now counts. You have your application number and then the filing date, and you tend to have some form of protection with that particular filing date because the moment the trademark is granted or the trademark is registered or the patent is granted, you can then take enforcement actions against infringers dating back when the application was made. But until you get a certificate, you cannot enforce your right. So that's one. The other thing also has to do with some unfair competition practices that takes place in Ghana. So you would have an investor from outside who has, let's say, you have some products, some that have trademarks that you are interested in, that you seek to register. But if you have distributors already in Ghana who have been importing and distributing the products here, by the time you come in to register, the distributor may have registered the product in his name. And then, because we have the first to file system, then it becomes a challenge because then the person becomes the owner of the trademark. So there are other situations where people take their competitors' trademarks and register them without their consent. And so when the competitor now wants to register, the first to file system comes in, and it means that the true owner of the trademark, will not have access to filing his own trademark. And then we also have issues with the Madrid system. With the Madrid system, it's supposed to be very efficient. It's supposed to be a fast thing, easy thing for investors. You put in one application in one country and then you go through the Madrid system and you designate Ghana and other countries. But because of the backlog in Ghana office, the 18 months automatic registration waiting period with automatic registration kicks in, and then the trademarks get registered without the trademark going through any substantive examination. So what happens is that you may have a Madrid trademark that has already been registered in Ghana. So you will have, let's say, I have Sarah as a trademark, and you register Sarah through the Madrid system. But by the time you register it, because it is not examined in the Ghana IP office, you realize that by the time you obtain your Sarah, there is another Sarah already existing in the Ghana register. So you have two Sarahs. And because we deal with the first in time, it means that your Sarah that you have registered will no longer will not be valid. And if steps are taken, it becomes a voidable registration. So when steps are taken to invalidate it, your mark will be invalidated. So your trademark, your Madrid system registration tends to be a bit weak when it comes to Ghana because of these challenges that we have. They don't rubber stamp per se. You know, the 18 months automatic registration period under the Madrid system, that is what kicks in. So Ghana will not respond to the Madrid application, and then it gets registered automatically. So the fact that the Madrid system has registered it, it's registered by the International Bureau of WIPO, doesn't mean necessarily that it has gone through the substantive examination in our IP office. So I have a few cases like that, and I'm hopeful to see the outcome, what the judges are going to. I have one critical one now pending, and I'm hopeful to see what the judges are going to say in respect of the dual registration.
Oh, me too. You have to keep us posted on that. That in
Yes,
itself could be a really interesting topic
I will.
for your next article. I mean, I don't know that that's widely known. So I think that's a really interesting point. Um, thanks for sharing that. Thanks for sharing all of this, really, Sarah. We're actually already at time.
Yeah.
It goes so quick. Thank you so much for your participation. Is there anything else that you wanted to
Just to
add?
say thank you to you and to Carlos. You guys are doing so well. Carlos, you're doing so well. So thank you for this, and thank you for sharing what goes on in other jurisdictions for all of us to learn from each other. Thank you so much.
Oh, well, it's our pleasure. And I mean, that's the point. We want to, shine a spotlight on women in intellectual property, the thought leaders from all around the world in our area. So thank you, Sarah. To our listeners, please like, follow, share with your friends and colleagues, but also feel free to send comments and questions. Till the next time, we look forward to seeing you and talking to women in the area of intellectual property all over the world.
The Women's IP World. The Women's IP World.
You have been listening to the Women's IP World podcast, hosted by Michele Katz from Advitam IP in Chicago, USA, on behalf of Northlands Media PR and Marketing Limited in the United Kingdom.
The Women's IP World.